let's get started. Welcome everyone to everything you need to know about the OSHA ETS. I think that's what we're calling this one. My name is Eric Meyer. Thank you for being here. If you are watching this on YouTube, because I did remember to hit record and we are posting this to YouTube, take a second right now, give us a like, subscribe to the channel if you'd like. If you have any comments, go ahead and do that. I'll remind you a few times throughout. But to those of us who are here live, thank you for making it in. We appreciate having you. Let me introduce the folks who are here with me today. We're going to do this Brady Bunch style, and I think this is how it'll show up on YouTube. To my immediate right is Gordon Berger. Gordon, good morning or good afternoon. It's 12:02 on the East Coast. How are you?
Good, thank you.
And why don't you tell the folks a little bit about yourself?
So I'm, of course, one of the partners in our employment section, and I'm just outside of Atlanta, Georgia, and of course, do a wealth of labor and employment matters for clients, advising on the employer side.
Awesome. Awesome. Thanks for coming here. As I go around, this is not a Brady Bunch square. This looks like a pentagon on my screen. I'm going down the pentagon to Amy Epstein Gluck. Amy, it's good to see you. You made it back from Puerto Rico, all right? Good to see you again.
I did.
Yeah.
I did. Thank you. Thank you. Our team was in Puerto Rico. I'm Amy Epstein Gluck. I am an employment partner at FisherBroyles, and I'm employment counsel to the firm. I provide employment compliance advice to organizations, big, small, medium-sized, to help them comply with federal, state, and local law and to prevent problems before they become even bigger. I'm thrilled to be here in the DC area where it is not cold or raining today, which is very exciting. And I'm looking forward to talking to you.
You have such luck here in Philadelphia area. It is raining and it's not that cold. Right, Sid? How's it about you? You're across the river. You're actually on the Jersey side. You're on the Pennsylvania side. How's it going?
I am. It's going very well. Thanks for including me, Eric. I am Sid Steinberg, also one of the partners on this terrific labor and employment team at FisherBroyles, and I also do employment law defense and former chair of DRI's Employment and Labor Committee. So some of the folks give a shout out for that, and looking forward to being here.
Awesome. Thanks for being here. Last but not least, up in the Pittsburgh area, we have David Renner. Good to see you, David.
Good to see you, Eric. Thanks for having me.
Yeah, thanks for being here.
Yeah. Like all of our esteemed colleagues here, I'm a labor and employment partner with the firm. And like you mentioned, I am just outside of Pittsburgh. And it is not quite raining today, but it is not exactly warm. But it should be a good day nonetheless.
Cool. Well, thanks for being here. Folks, a couple of housekeeping things. If you want to use closed captioning, you certainly can. And if there are any issues with that, let me know using the chat window. But you can go right down to the bottom, kind of like bottomish right. You'll see that CC button. And we will turn on the closed captioning. I think it is now turned on. I think it wasn't turned on, but now it is. Everyone should be able to use it. I am, let's see. All right. It is enabled. I'm going to turn the transcript off on my screen, I think. Sorry. Let's see if I can fix this. I apologize, folks. There we go. All right, great. What else do I have to tell you? Oh, yes, the legal disclaimer. We're lawyers. You're not lawyers. You may be lawyers, but don't get it twisted. We're not giving any sort of legal advice to you today. We're not creating any sort of attorney-client relationship. In fact, we assume that everything you ask is hypothetical and you're asking for a friend. So that's how we'll answer your questions. And if you have questions, please do use the chat box. We will try to get to as many of them as we can. We have, our own spiel. I see someone is asking about a slide deck. We don't do slide decks around here. We just jibber jabber for an hour, and time goes by pretty quickly. But if you have questions, please do put them in the chat window. Okay, so here's what we're going to talk about today. We are going to focus on the OSHA emergency temporary standard. We're not going to talk about federal contractors really, and the executive order there. We're not going to talk about the CMS. We've got enough to handle dealing with the OSHA ETS, and you know, at the end, possibly if we have time, we'll opine, as lawyers do, on whether we think it's actually going to hold up or not, and whether you've just wasted the next 53 minutes preparing for something that might not actually happen. But you know, we've got to fill you up with knowledge anyway before we get there. So, Amy, good morning, good afternoon, excuse me. Why don't we talk about just the general scope and application? Like, who does this cover? This OSHA ETS?
Sure. So I'm seeing all these great questions in the chat, and I can assure you we are answering all of them. But for now, you know, we're just going to dive into a little bit of the big picture of the OSHA ETS and who it covers. When we last spoke in, I think it was October, was it October? The big question was really, what does 100 or more total employees mean, right? Because generally this emergency temporary standard, or ETS, applies to all private employers with 100 or more employees. So now we have so much guidance on this. It's 100 or more total employees at any time that the ETS is in effect. Okay. Now, 100 or more employees is across all US locations. One question that we got last time and actually came up in practice for me yesterday was, what about a global workforce? I will share that OSHA doesn't really, OSHA focuses on the US workforce. So you're looking at 100 or more total employees at locations across the US. You count part-time employees in that 100 employee count. You count temporary and seasonal employees. You do not count independent contractors. You do not count people who work outside full-time. Who else don't you count? You count temporary people. You do not count leased employees. It applies regardless of employees' vaccine status. So it's not like you exclude people who are already vaccinated and it wouldn't apply to them. Scope and application are two different things. When we talk about scope, we're talking about counting number of employees. When we talk about application, we're talking about who the standard actually applies to. So the ETS, the biggest question we've really seen was, what about remote employees? Big picture is that the standard does not apply to employees who do not report to a workplace where there are other human beings, right? Where there are coworkers, where there are customers, where there are clients, where there are vendors. So it doesn't apply to folks who work from home or who work exclusively outside. They're counted, so they're within the scope, but the standard doesn't apply to them. And if you think about it this way, it makes sense. If they're not interacting with other people, they're not presenting a risk to other people, whether they're vaccinated or not. Franchises, the way you count franchises, a franchisor and a franchisee would be considered separate entities, but each franchisee would only count employees of that individual franchise. Etc. So the ETS, all 490 pages of it, which I'm sure you all read in detail, gives a bunch of examples, which just makes my employment lawyer heart go pitter pat. And I put them on our FisherBroyles blog when this ETS came out on November 4th. And I'll just give some of these examples so you can see how scope and application interact in practice. So if an employer has 75 part-time employees and 25 full-time employees, the employer is still within the scope of the standard. It's got 100 employees because we count part-time and full-time. But the 75, they all are within the scope of the ETS. If an employer has 150 employees, 100 of whom work from home full-time and 50 who work in the office, The employers within the scope of the standard, so it's 100+ employer, but only the 50 who work in the office have to comply with the standard, because the ones who work from home full time and don't go in. So you can see that there are a lot of different ways to count this. Generally speaking, you're looking, that 100 employee threshold is pretty wide, and covers many more employers than it applies to. All right. If an employer has 100, a couple of more examples. If an employer has 150 employees and 100 do work in customers' homes, mostly working from their cars, like sales folks, right? And rarely or never report to the office, the employer would fall within the scope of the standard. If an employer has 200 employees and they're all vaccinated, it would still be covered, but everybody would be vaccinated. If an employer has 125 employees and 115 of them work only outside, that employer would be covered as well. Multi-employer locations, like construction companies or contractors, not federal contractors, general contractors, real estate and such. Each company counts its own employees regardless of where they work. Okay, so if 100 employees, that 100 employee threshold has to be as of November 5th, the day that the standard went into play. So if you have a fluctuating workforce, you have employees coming in and coming out over time. If you have 100 employees as of that date of November 5, then your organization is within the scope for good, for as long as the standard applies, even if the number of employees fluctuate over time. As Eric mentioned, federal contractors and subcontractors are not covered by this specific ETS because they're covered by a totally different one. Folks in healthcare settings doesn't apply. This standard doesn't apply to them. They have their own. They're covered by the healthcare ETS. And the same is true for federal agency employees, except for the U.S. Postal Service. Postmen, post people are treated as private employer. So that's really the scope and application, who the ETS applies to and what comes within the scope. We've also had a lot of questions, and I've dealt with a lot of clients asking about preemption questions that I want to touch on for 1 second. Meaning, some states have state plans that talk about OSHA guidance. Some states ban vaccines or masks. So the OSHA standard about vaccines, mask wearing, and testing preempts any state laws except for a federally approved state plan. Okay, that means if a state or local requirement that bans or limits any employer's authority to require vaccination or mask or testing, the OSHA standard preempts that. And that's really where you're getting a lot of this litigation going on. The standard does not preempt higher requirements. Like if you, as an employer, if you want to mandate stricter requirements than what the standard has, you can do that. Could always make the workplace safer than the OSHA standard. The OSHA standard's a floor, but employers can always do more. I did not mean to make that rhyme, but it's good that it did.
Good way to close it out.
I know, right? And my last point is state plans. Several of you have state plans. If you're in Virginia, if you're in New York, if you're in Michigan, state plans must amend their standards to be the same or at least as effective as this one within 30 days. And that's all.
Thank you.
Yes.
How
I
about
like the examples?
They're very good. Gordon, vaccination requirements, right? So, I mean, this is the vax or test emergency temporary standard, but I think most employers are probably shifting in the vax direction if they haven't been doing so already, just because it's easier probably to administer, although there could be business ramifications of doing that, but that's for another discussion another day. But the vaccination requirements, what are they under the emergency temporary standard?
All right, so let's talk some terms of art. So fully vaccinated is the kicker. Fully vaccinated is basically someone who has had either the single dose Johnson & Johnson or the 2 double dose, and they are 2 weeks post their last dosage. So there are a number of other doses that can be approved, but it's usually Moderna, Pfizer, Johnson & Johnson. But there are others that are approved by the FDA or by the World Health Organization, or even there's some clinical trials going on in the United States where that's considered fully vaccinated. Now, some folks have asked, well, what about somebody who has previously contracted COVID and they may have antibodies in their system? So is that considered, because they have natural immunity, fully vaccinated? And the answer is no. There's no exemption for natural immunity or for antibodies. And the fully vaccinated definition that I provided is the standard that must be used.
But you can't require, and I'm skipping ahead a bit, if someone has had COVID within the last 90 days and recovered, you can't require them to test weekly if that's the option they go for. So otherwise, you test people weekly, but if someone has had COVID in the last 90 days and you don't, they can't be required to test weekly. Anyway, I'm sorry about that.
Right. That's the conventional wisdom, is there's a margin of error for false positive or negative because the potential of the antibodies are still in the system. So the 90 days has been used as a measure. That's correct.
But for folks who get vaccinated, they get paid to get vaccinated, right?
Yeah, so let's talk about the employer obligation to pay folks for vaccination. So first, are you required to use personal time or sick time if you're an employee to get vaccinated? No. The ETS has a specific proviso that says that, first of all, employers have to allow reasonable time during work hours. Although if an employee wants to go on a Saturday and it's a non-work day, they can do that. But if they go during work hours, you are to pay up to 4 hours of paid time at the regular rate of pay. And that's not time that would otherwise be available under a normal PTO, sick leave, or other type of paid leave that an employer has. It's independent 4 hours. All right. So then you have the other issue, which is, okay, so let's say one of your employees goes and gets vaccinated. You pay them for the time of vaccination. What about if they have side effects and they need to recover? So how do you pay them that way? Or what's the obligation? So if you have an accrued paid sick leave available, the employee hasn't exhausted it, and you have a paid sick leave plan, you as an employer can require that employee to use that paid sick leave for recovery. And it's for both doses. Okay, so if they get the double dose, this applies. So does the paid sick leave. What you can't do, though, is say, well, we're gonna take an advance against your sick leave, or put someone in a negative paid sick leave bank position because we're going to advance that as a result of you now having potential side effects. Nor can you require somebody to borrow against paid leave for the recovery period. And then, okay, the other question comes, what's our obligation if we have to remove somebody from a workforce? By way of example, it's a person who's been testing weekly and they test positive. Do you have to pay them for being removed from the workplace? No, but there are the laws, regs, or you might be subject to a collective bargaining agreement, in which case there may be an obligation. But under the ETS, that's not required. That's not to say, however, employers can't be more generous, and you can choose to pay employees for time required for being removed, for the quarantine period to return. So you can still be more generous than what the standard requires.
Sounds good. I'm going to talk a little bit about accommodations, and emphasis on a little bit, because I feel like we've exhausted this over past Zooms, and you've probably read plenty online. I just want to focus on a few things. And this is more from just personal experience in dealing with clients and answering questions. The health accommodations, disability, pregnancy, they seem to be fairly open and shut, right? Someone comes to you and they say they have a reason they can't get vaccinated, a health-related reason. You say, all right, give me a doctor's note. Doctor provides a note that says so-and-so can't get vaccinated. We're done. You document that. They don't get vaccinated. They're testing weekly. Okay. They now fall into the other category. And it's pretty easy, I think. Pregnancy the same way. While the CDC has said there's nothing about pregnancy per se that should prevent someone from getting vaccinated, right? Someone who's pregnant could have an underlying disability. And someone who's pregnant, their doctor may say, like, this person shouldn't get vaccinated right now. Okay, you're not a doctor. Just accept that and move on, right? And move them into the weekly testing requirement. Religion, okay? And anyone else on here who wants to chime in, please do. Here's what I'm seeing with religion, okay? You could fall into one of, I suppose, two buckets as the employer. You could be as long as they submit a form that says anything about religion, I'm going to exempt them. And I've had clients that basically do that, okay? We're not going to question the sincerity of their belief. It may look a little weird on paper, but whatever. We move them into the testing bucket. Fine. The other way you can go about it is you can push back a little bit. And, one of the ways that you can push back, especially when someone says, I've got a religious objection to getting the COVID-19 vaccine, is you ask them, well, okay, what other vaccinations have you gotten in your adult life? And what is it about, and if you've gotten other ones, what is it about the COVID-19 vaccine that is, that offends or your sincerely held religious beliefs? And then wait to see what the answer is. And if it's a reasonable answer, then you put them in the weekly test bucket. If it's not, then you reject the accommodation request. You could do that. If you haven't, tangentially, if you haven't checked out my blog post today about religious accommodations and the right form to be using, please do go head over to the employerhandbook.com and check out the post today. Special shout out to EEOC Commissioner Andrea Lucas. She is a fantastic follow. You should connect with her on LinkedIn. She's been pumping out some great content on this type of stuff. Commissioner Keith Sonderland's also a great follow on LinkedIn as well. But make sure that you're using the right forms. I mean, basically, religious accommodations, you don't want to fight them too hard. That's not the hill on which you want to plant your flag and defend, right? You can push back a little bit in the right situation, but otherwise don't. The final thing I wanted to flag, in case anyone missed it, is the news about a major airline. I won't call them out. It sounds like Boo United, but it's not Boo United. So they had an issue with their workforce where if you applied for an accommodation, religious or medical, and you were accepted, you were put on indefinite unpaid leave. And the employees who were impacted by that sued, seeking an injunction to stop this. And the standard for an injunction is you have to show that you're irreparably harmed, and they weren't able to do that. Okay, so the injunction was not entered. However, a Texas federal judge made it really clear that this practice of putting people who request accommodations on indefinite unpaid leave may violate the ADA or Title VII. So in the long run, these employees may have a tenable lawsuit under one of two federal anti-discrimination statutes, let alone maybe some state law as well. And that could cost the airline some money. So be careful about the accommodation you choose. If it's not weekly testing, if it's something else that's going to deprive someone of income, you want to be sure that that is really the only available option to you, other than something else that could be more reasonable. And that's all I have to say about accommodations today. Dave, how about, we talked a little bit about, if you're not vaxxed, you're getting tested. What are the testing requirements under the ETS?
Yeah, so testing. As you said, it's a vax or test mandate. So according to the ETS, all of those employees who are not fully vaccinated, they need to be tested at least once every 7 days and provide documentation to their employer of those test results. So note fully vaccinated. As Gordon had mentioned earlier, fully vaccinated is 2 weeks out from your last dose. So either the 2-shot mRNA or the 1-shot J&J. So if you have those employees, as the ETS is currently written, after December 6th, those employees who are in the process of becoming fully vaccinated but have not yet reached that 2-week threshold, those employees are going to need to submit to the weekly testing requirement until those 2 weeks kick in. Amy may have mentioned this, I think she did, but those remote workers or those workers who don't come into the workplace, you don't have to worry about testing those folks unless they come to the workplace. And if they come to the workplace, they have to show proof of a COVID test and provide the documentation of that test before they enter the workplace. I won't touch on about what happens if you had COVID in the last 90 days, but during that 90 days from your diagnosis or your positive test, you do not have to receive, you cannot require those employees to be vaccinated. The big question, I think that, well, I guess before I get into that, testing, there are a number of different COVID tests out there, and how do we test for this? So, under the ETS, a COVID test, it has to be one of those cleared and approved tests, including those under the emergency use authorization, excuse me. It has to be administered in accordance with the instructions for that test. And the test, and this is the big one, it can't be both self-administered and self-read unless that is being observed by the employer or some type of telehealth proctor. So I've had a few clients that have wanted to, or had a plan in place for when this thing came down the pike, to have the employees test themselves at home. And that this part of the ETS is throwing a wrinkle into some of that, because now, do they have to bring the test with them, do the test at the work site, or do you have to get all your HR folks on FaceTime to see the results of the test? Because those at-home testing kits are not going, if the employee's doing it themselves and reading the results themselves, that's not going to fly under the ETS. Antibody tests, it's important to note, antibody tests don't count under the ETS. You have to do either an antigen or a diagnostic, your PCR tests. Now I think the big one, who pays for the cost of the tests? That's been the question I think that I've gotten the most throughout all this. And the answer, according to the ETS, is that no, the employer doesn't have to pay for the cost of the test. The employees, you can pass that or make the employee pay for the cost of the tests under the ETS. Keep an eye out for state and local laws that might say something different. I know at least Kentucky, New Jersey, and Pennsylvania have some laws on the books that say that under certain circumstances you may not be able to pass those costs on to your employees. And the other big one, and OSHA punted on this in their ETS, is who pays for the time spent going to get tested. First of all, you've got two categories of employees we all know, exempt and non-exempt. This is kind of what I'll call a non-issue or a very small blip on a radar for exempt employees, because exempt employees, you're paid the same salary all week, and so you don't have to worry about it. But for those non-exempt employees, well, I guess before I get into non-exempt, those exempt employees, there are some circumstances, I suppose, where you should be careful about when they get the test, because if an non-exempt employee, or excuse me, an exempt employee has to be paid their full salary during any week in which they perform any work for their employers. Query whether receiving a mandatory COVID test is work for the employer. If they're otherwise off and not necessarily using vacation time to get paid, and they get that test in a week in which they're not supposed to be performing any work, that might trigger the obligation to pay that full salary for that week. I think those circumstances are going to be pretty few and far between, but something to keep an eye out on. But for non-exempt employees, the OSHA ETS punted on this. There's no guidance under the ETS. No guidance from OSHA on this. I have heard that the Department of Labor is going to come out and provide definitive guidance on this issue. When, I don't know. What it's going to say, I don't have a crystal ball, but my guess is going to be that the DOL is going to say that the employer has to pay for the time spent going to get tested. And I think that's because under the Wage and Hour Division's current guidance, pre-ETS for COVID testing, they did seem to suggest that if you're going to require employees to get tested outside of normal, that time would be compensable, or likely to be compensable. So I think that if I were to bet, I would bet on the fact that testing or time spent testing is going to be compensable time under this new ETS.
All right. I guess I'm up. I get to talk about positive tests and what you do. Actually, before we do that, let's reset. It's 12:30 here on the East Coast. Welcome, everyone. Thanks for hanging in there with us. We've got 500 people here today. Thank you for all being here. I'm Eric. There's Gordon. Amy's down there along with Sid. Dave to my left. We're talking OSHA ETS. For those of you who are watching this on YouTube, hey, we're halfway through. If you like what you see, give us a like, subscribe. There's going to be more content to follow. I see a bunch of great questions popping up. I promise we'll get to as many as we can. Keep asking them, please do, but we're going to run through a little bit more on our agenda and we'll save some time for questions near the end. I'm going to buzz through what to do if one of your employees tests positive real quickly. If someone tests positive, do you have to remove them from the workplace? Heck yes. Okay, get them out of the workplace. If your employee tests positive, how do they let you know? They've got to let you know as soon as practicable before the start of their shift, or if somehow they get their test results while they're working in the office, that'd be awkward. As soon as safely possible during the shift. That's what OSHA has said. We've already touched upon this. Do you have to provide PTO under federal law if someone tests positive and needs time off? The answer is no, but check state and local law. If you have a collective bargaining agreement, you may need to do it too. Obviously, if someone has sick pay under one of your policies or general PTO, I imagine you can let them use that. Here's some of the things that the ETS does not require, okay? It does not require record keeping of employee notifications of a positive COVID-19 test or diagnosis of COVID-19 by a licensed healthcare provider. You do not have to keep a record of that, okay? It does not require contact tracing. Makes you wonder how this is for a grave danger if there's no contact tracing. Maybe I'm foreshadowing something near the end. It does not require removal of an unvaxxed employee who comes into close contact with a positive employee, even though the CDC says you should do that. CDC says someone who's in close contact who's unvaxxed should stay at home for 14 days. I suggest you follow the CDC guidance. What if someone tests positive? What are the return possibilities? Well, if they receive a negative test on a nucleic acid amplification test following an original positive COVID-19 antigen test, they can come back. If they satisfy the CDC's return to work criteria, so we're talking about 10 days from symptom onset, after resolution of fever for at least 24 hours without the use of fever reducing medication and improvement in other symptoms, they can come back. And they can also come back after 10 days if they remain asymptomatic. Also, if a doctor gives them the green light to come back, now hopefully the doctor knows what he or she is doing, they can come back to work under the OSHA ETS. I'm done my segment. Dave, I'm going to kick it back to you. So I said a little bit about what records employers don't have to keep, but damn, there's a lot of records they do have to keep, don't they?
Oh yeah. So I guess breaking it down, I'm going to say there's two main categories here. You've got to keep to talk about testing, like I was just talking about. The employer, for the length of that this ETS is in effect, which is for 6 months, you've got to keep a copy of all of those test results. Sorry, employers, that's going to be fun and exciting and quite burdensome if you ask me, but you have to keep a copy of all those test results. And you also have to have, for those vaccinated employees, you got to have each vaccinated employee provide something that the ETS calls an acceptable proof of vaccination status, including partial or fully vaccinated. So that can be, according to the ETS, a number of things. Your vaccine card that you've received after having been vaccinated. Electronic and photocopies or PDF copies are okay as well, but you can't just have the employee, like you go into, like some places are requiring you to show proof of vaccine. You can't just hold it up on your phone, the picture on your phone, and that comply under the OSHA ETS. No, you have to find some way to maintain this record. So the employee has to send you that picture or give you their original Vax card to make a photocopy of. Their medical records also could work under the ETS that's showing the vaccination. Something from the pharmacy showing proof of vaccination, or their healthcare provider showing proof of vaccination. Some other type of official record that they're calling it, showing that shows the type of the vax administered, and the name of the healthcare providers that gave it. And there's also an exemption. I don't know how. I suppose it's possible. But everything that I've been hearing about, you protect this vaccination card basically with your life, better than your firstborn child or your only born child. But what happens if you lose it, or you drop it down the drain or something like that, or the dog eats it? That's okay. An employee can provide what they're going to call a personal, they have to provide some type of sworn statement to their employer that says that they are either fully or partially vaccinated, saying that they lost or they otherwise can't produce their vaccine card. And then it has to include specific language basically saying that it's subject to the penalties of perjury. It doesn't exactly say that, but that's generally what the language reads, that you have to submit that. If they can't provide proof of vaccine, then you treat those folks as unvaccinated. So also, and Eric, I don't know if you want me to talk about this as well, but in terms of producing these records, if they're asked for, you have to, by the next business day, provide a copy, or must make available for examination and copying. If an individual asks for it, the copy, their COVID vaccine documentation, or any COVID test results required for the ETS, by the end of the next business day of the request. And you also have to keep a roster of all those employees who are vaccinated, and the total number of employees that you have in your workplace. And if OSHA asks for that, you've got 4 hours to provide it. So you've got to make sure that these records, you keep these records, you have these records, and that you can pull them up within at least 4 hours. Otherwise, there could be a violation under the ETS, which could get pretty costly.
Yeah, another request you got to respond to is, again, by the next business day, is if an employee or an employee representative, so presumably a union, requests, the employer must make available to the requester the aggregate number of fully vaccinated employees at a workplace, along with the total number of employees at the workplace as well. So it's not just for them. Now, they're not going to identify who actually is vaccinated, who isn't, but there are a lot of informational requirements.
Eric, can I just jump in just a little bit? Some of the issues that get raised. The first, that attestation that is contemplated, I think it also requires that the employee basically attest that they use their best efforts to obtain a card, even if they lost, if they're saying I lost it or the like, that there is an expectation that the employee will go back to the physician, to the pharmacy, to whatever, and make best efforts to try to obtain that information. And then, and only then can they attest that they're unable to get that, which puts, the intention obviously is to put as much burden on an employee as possible in terms of this attestation. I mean, obviously, it's grossly disfavored, to do that.
And if you
We're going
lie
to
about
talk.
that, and if you lie about that, you're probably going to jail.
Well, at least you're going to have to say that you understand that you could potentially go to jail
Yeah.
about that. The other issue, and we're going to talk about the union ramifications in a minute, is that potentially, if an employee were to go and say, "Look, me and my buddies, we're all concerned about the vaccination rates. And so I want to see the aggregate numbers and the like that you just referred to." Query whether that's taking collective action in a non-union setting and implicating Section 7 rights. I know I use a lot of buzzwords. We'll talk about the union issues in a minute, but I think that may well be because, my sense is that the ETS is specifically encouraging employees to do that. That's the whole point of this, aggregate number type thing. And it contemplates that employees will then whistleblow or report back to ETS or to OSHA, excuse me, the issues in their own workplaces. So
I bet it does. I bet it does. I mean, Section 7 of the NLRA is terms and conditions, not just wages.
yeah.
Great point.
Do you think it's any coincidence that the EEOC, NLRB, and
Yeah.
Department of Labor announced that they're paying specific attention to retaliation? They're having a, what are we calling it? A
Task force.
virtual dialogue with employers on not retaliating.
Yeah.
Yeah.
But again, we'll talk about the tensions of that in a minute. So go ahead.
So we'll get back to Sid in just 1 second. So we do want to hit the union ramifications, but Amy, we've talked, there's so much information here. And usually when employers have to deal with a lot of information and communicate that to employees, it needs to be done in a policy of some sort. We've already talked a little bit about the other information that needs to be provided upon request, but can you focus a little bit about what these policies should look like and how employers can develop them?
Sure. Well, there will probably be some length, and I'm sorry in advance because I know that over the last 20 months, you've been drafting policies and then revising them again. So they have to be, your policies have to comply with the standard. OSHA has specific templates, that you can customize for your workforce that contains all the information you have to provide. Before I give you the laundry list of what has to be provided, I think it's worth noting a couple of things about how you provide the information to your employees. If you have a multicultural workforce where English is not everybody's first language, you have to provide policies in a language and at a literacy level that the employee understands. I think that's an important point because it's got to include everyone. And OSHA gives templates for all of that. You can provide the information however you want. It doesn't have to be in person. It doesn't have to be electronic. There doesn't need to be a training on the standard. So in whatever manner is effective in your workplace, depending on what type of workplace you have, provide it that way. So the policies and procedures have to really show all the things that we were just talking about, the process that the employer that you'll use to determine the employee vaccination status, the time and pay or leave they're entitled to for vaccines and to recover from any side effects that they experience after being vaccinated, procedures, that employees have to follow to provide notice of a positive COVID test or diagnosis of COVID by a healthcare provider. And I think this should sound familiar to most employees, to most employers, because we've been doing this, for a while now, and how we're providing notice to the rest of the workforce when someone tests positive. But these are more specific. Additional information is procedures to be used for requesting records, and additional information about an employer's policies for testing and face coverings. There are naturally notices and fact sheets that have to be addressed, and information has to be provided about COVID vaccine efficacy, safety, and the benefits of being vaccinated, which is available on the CDC website. And we could put that information in the
Put it
chat.
up right now.
Okay, good. I was going to do that after, but thank you. And a note, what we were just talking about the EEOC, DOL, and NLRB task force. The standard requires employers to provide employees with information about how to report, any violations or any, discrimination or retaliation for whistleblowing, right? For filing an OSHA complaint, for reporting a work-related injury or illness, or otherwise exercising any rights. OSHA has fact sheets in English and Spanish. They need to be provided. If you don't have any Spanish speakers, you don't need to provide that in your workplace, but generally fact sheets in the employee's main language has to be provided. Prohibitions under the OSHA standard has to be provided about criminal penalties associated with knowingly supplying false statements or documentation, which really plays into the issue we were just talking about in terms of the employee attestation. Okay, so all of these fact sheets have to be provided to your employees. As I mentioned, OSHA has a template for a lot of these issues. And of course, there are accommodations templates. We have forms, OSHA has forms, and it all needs to be provided. So I hope that is helpful for you. There's just so much information, and it's all going to go into a policy.
Cool. Sid, unions and General Counsel Abruzzo's recent missive about collective bargaining during an ETS. What do people need to know?
Well, it's interesting because, you can tell that that the administration is full of lawyers because they feel strongly both ways on these topics. Because on one hand, of course, the administration and obviously through OSHA, strongly wants every employee to be vaccinated, and employers, are specifically throughout the ETS are directed that we really want you to mandate the vaccines. But there is this alternative approach, the testing approach, should you want to do that, but we really want you to mandate the vaccines. And then the question, of course, is, well, so what happens in collective bargaining situations? And just about 48 hours ago, the Office of General Counsel, it was not an official General Counsel memo, it's actually an operations memo. So if you try to go on the website, and maybe we can actually post the operations memo, but if you try to go on the website and you look under GC memo, which is how those are listed, it's not there. It's under the operations memo category. So in any event, in addition to the strong policy in favor of vaccine mandates, the administration, of course, is very supportive of union rights and collective bargaining rights. And so what the Office of General Counsel came out with is saying that because the ETS has discretion in it, that is, employers can either mandate the vaccine or can offer testing and masking, while you don't have to bargain over federal mandate compliance with federal mandates. This is not actually a mandate. The employer has the discretion and therefore would be required to bargain over the implementation of the testing, of the mandation versus testing, and that would be a mandatory subject of bargaining with the union. Further, the memo suggests that that an employer would be required with a collective bargaining agreement would be required to bargain over the effects of the protocol that is put in place. So how that's going to be put in place, the timing, the process, and then what actions would be taken at the should someone violate either the mandation or the testing, that also would be a subject of bargaining. So you say, okay, so we have to bargain over everything, right? Well, not necessarily, because if many collective bargaining agreements, many contracts will maintain a strong management right clause to provide rules in the workplace regarding health and safety. And so if you would have to go back to the contract itself and see the strength of that management right clause to simply implement health and safety rules. And if you then can take the position that this is a health and safety rule in the workplace, then you don't have to bargain over it, or actually you've already bargained over that. And under the collective bargaining agreement, you have the right to implement a health and safety rule that is arguably mandation versus testing or masking into the workplace. So, like with all of these issues, the question becomes, what does your CBA say? What does the union contract say? And how then does that get implemented? The other point that I'll just circle back to, which we talked about just a couple of minutes ago, is collective action. And non-union workplaces are, again, still subject to Section 7 rights. That is collective action on the part of employees. And as I noted, since almost certainly employees will come in and say, look, I'm acting not just on behalf of myself, but on behalf of my coworkers. To the extent that they do that, they request information. Obviously, we have the anti-retaliation provisions that if they act, even in a non-union work environment, if they act on behalf of others, that is considered to be collective action and therefore implicates the National Labor Relations Act, which then calls in the anti-retaliation provisions. And so, the clear guidance is don't retaliate against employees who are requesting information or taking any action under the mandate or testing requirements.
All right, good. Gordon, welcome back. I think what I want to do, we have about 5 minutes left. We were going to talk about the OSHA reporting requirements. I'm gonna give you a pass on that one, Gordon. I don't want to put anyone on the spot, but I'm gonna put everyone on the spot. Put your personal feelings aside about the mandate. This is not a reflection of your personal feelings. Raise your hand if you think that this mandate will survive judicial scrutiny. Okay, we all agree. All right, now let's go to the Q&A. And we're not saying folks don't prepare, we're saying do prepare. I think that's the overarching message here. We're doing this for a reason. It is very possible this mandate could hold up, at least, but we don't think it will. There are a lot of people in the chat who are putting up, only 5 people put it up in the chat. So yeah, you guys too can vote. Anyway, let's get to some questions. I saw a couple good ones here. Someone asked, is it 4 hours of PTO for just the first shot in a 2-shot series or both? It's both, 4 hours each. So, hey, if your employees get the Johnson & Johnson, then you're saving yourself a little money. My good friend and former colleague, Luke Wise, shout out to your father as well. Please tell him I say hello. Asked, if someone already got vaccinated, do you have to now give them retroactively 4 hours of paid time off? I think the answer is No. Good question. What about, I see a lot of people asking about booster shots. Do booster shots factor in any way into the CTS? No. Technically, I'm not eligible to get one yet. So, until I think everyone's eligible, we're not even going to be talking about that, but that might be, I think that's just overkill. There are a lot of questions about natural immunity. We're not answering any of them here, okay? OSHA doesn't care about your natural immunity, all right? The only time they care is with the weekly testing. Otherwise, they don't care about your natural immunity, all right? Let's see, what other questions do we have? Oh, here's a question. Can vaccination status be shared with the employee's manager so as to enforce that unvaccinated people be masked without violating the ETS? Anyone want to take that one?
Sure.
Go ahead, Gordon.
Answer is yes, but questions beyond the reason behind it and so forth shouldn't be asked, because that can get into ADA and other considerations, because you're getting into potential genetic and or disability related information.
Someone has asked, what if the person no longer has sick time available? Is the time, I think the question is to get vaxxed unpaid. No, you got to give them 4 hours. Even if they have sick time available, you got to give them 4 hours for each shot, okay? It's a reasonable amount of time off. You provide a reasonable amount of PTO to recover from the side effects. What's a reasonable amount of time? The OSHA presumption is 2 days. Could be sooner. But if you have a policy, you'll see that in the form policy, 2 days, up to 2 days to recover, that's presumptively fine. Let's do a couple more questions. Is the employer responsible if the employee gets vaccinated and has a life-changing reaction? I don't even know what that means. Why did I read that one? I'm gonna let that one go. Oh, someone asked, I'll close out in this, and then we'll do our official close, because I dealt with this, and I think maybe some other folks have. What about exemptions, medical or religious, against testing and mask wearing? I actually had one where someone had a religious exemption for vaccine and testing, but not mask wearing. So they check 2 out of 3 boxes. You take each one, you take each one in isolation, and you see if there is a reasonable accommodation that can be provided. Now, if someone can't mask, they can't test, and they can't get vaxxed, I would suggest to you that in most, if not all circumstances, in an enclosed workplace with other people around, that person's a direct threat, and that person can't come in. If they're working outside, if they're working remotely, whatever, that's a different story. But in most situations, if you check all of those boxes, then that person can't work for you. We had so many other questions we didn't get to. I apologize, folks. These things happen when we have so much to cover, but thank you. Thank you for coming out today. I still see some people in the waiting room. Come on in for the last minute. We're closing it out. People have rotated since Gordon went out and came back in. So I'm just going to look to my right to Sid. And anything you want to say to the folks as we sign off here?
It's incredible that you can have hundreds of pages of NETS. We don't kill trees on these things anymore, but hundreds of pages in the Federal Register, and yet so many questions and so much unanswered, which of course, Eric, as you alluded to, raises questions regarding the viability as a whole. Anyway, thank you all so much. This has been a lot of fun. I'll pass it back to Eric.
Great. Gordon, any closing thoughts?
Yeah, just on the union issue. So bear in mind, the reason I didn't raise my hand about the prognosis of this thing going through is unions have vehemently opposed over the years, and ETS hasn't been used successfully since the 1980s, partly because unions have fought for the rights of their workers to have freedom from these type of restrictions.
I thought I saw somewhere where they filed a brief where they came out now in support. So who knows? It's very strange. Amy, anything? Any good words for our folks who are still hanging around?
Sure. I would say continue to look at your EEOC guidance, especially about the confidentiality of these medical records. Remember, the ADA continues to apply to all of these issues. like Eric was noting about the employee who couldn't get vaxxed and couldn't test because of a religious reason. These are all really determined on a case-by-case individualized basis. And the EEOC guidance remains a fantastic resource in conjunction with the CDC and the standard.
Awesome. Thank you, Amy.
Mhm.
Last but not least, Dave, what nuggets of wisdom do you have for the 366 people who are still hanging around here?
Thanks. We alluded to it. I know I did a little bit earlier, but I think we spent the last 61 minutes talking about the OSHA ETS, which is a federal regulation that covers employers with 100 or more employees. Let's not forget about state and local laws that could be impose more or higher requirements. So anytime you're working on these policies or you're making any type of considerations for an accommodation or an exemption or anything having to do with your employees, don't forget about your state and local laws, and contact your counsel to make sure.
Awesome. I have posted all of our LinkedIn information in the chat window. Please do connect with us. If you want to check out our law firm website, that's fine too. Most of all, I want to thank all of you for coming out. We do enjoy these, especially when people turn up. So please tell your friends. Maybe we'll do another one again, giving you an update on the legal status of the ETS, or maybe we'll shift over and we'll talk about federal contractors, whatever topics you want. Connect with us on LinkedIn. Let us know what you'd like to hear. If you're watching this on YouTube, let us know in the comments below what you'd like to hear from us on, and we'll see if we can put together a presentation, whether it relates to vaccinations or anything that could relate to human resources, HR compliance, or employment law. So again, thank you very much, everyone, for coming out. Have a great weekend, and let's go Eagles. Bye.